put in our hands.
Who give into them? When you go to the chief of them, it is their chief of the destruction.
For the people who cry for the dreams that
the process they are saying is consultation. The time said they are saying consultation. When you go to, they are also doing consultation, but they have added another level talking about civil society organizations. And let me allay the fears of colleagues. Names are not given in this structure that you should be a member of the structure given under the NSCCG. They are representing institutions. The TISEC representing institutions. The PROSEC representing institutions. So when you are going, you cannot say Mr. Derisenge was there in that case. No. If Chief Minister is there for the National Security Council, the Chief Minister is there. So when it is gone, if it's fired by the President, the one coming next will take the seat. So that even the issue of talking about female cabinet represented has no place. In fact, in this bill, we are not talking about individual names, but talking about institutional representations. Because these are well professional, well trained. So that is the structure we have to propose. And I want to hope my colleague is taking note for this clarification. So we are talking about emerging institutions coming. We should make provisions for them, and we should not talk about issues that we disadvantage them, but because innovation, they are not innovator. So I wonder why you are presenting a structure to us with no innovation, Chief Minister. You are an innovator. I'm not saying that in your bill, but we progress and we will think about that when we come to the committee stage, we will deal with it. So for your edification, when I mentioned the chiefdom, the security committee, you go to clause 9, clause 9F. That is your reference. They are talking about civil society organizations. Mr. Speaker, honorable members, I like this you mentioned. The quality of intel you get, the quality of the intel you get, ascertaining the veracity of what you have received from the chiefdom level to the dissect level to the process level, taking it from the NSCC level, right up to the Security Council level to the President. The CISA, the man who is in charge of guarding of this intelligence, in collaboration with the NSO, they should be able to verify this information that this is fact, and they are not giving any information that can be in doubt in the minds of those who are at the National Security Council level. So what they have done, they can either go over the intel they have gathered, or they do another intelligence gathering, so they can be clear in mind before presenting it at the National Security Council. So, Colin, let me take you to clause B, page 16. Clause B, page 16. I may read for the edification of the House. Page 16. B, that is at the top. At the top, that is Joint Intelligence Committee under 10. Then you have now 10 F6. B of that. Assess the veracity of the intelligence and information received by intelligence agencies, CISA, and where the intelligence gathered are not clear, the Joint Intelligence Committee shall direct that more intelligence be gathered. Or where the intelligence gathered is clear, it shall brief the National Security Council. It shall brief the National Security Council. Or the National Security Council coordinating group that the NSCCG, or it shall give directives for the operationalization of intelligence as appropriate. So they are very careful. They first establish how they can now ascertain the veracity of the intelligence and taking it up to another level for actions. That's why they said they operationalize it. Mr. Speaker, honorable members, every time we talk about drug smuggling, we talk about trafficking, human trafficking on the high seas. We talk about our shortage of the livestock and the marine sectors, depletion of our fishery product or other products in the marine sector. We start to talk about the Joint Maritime we talk about the Joint Maritime Committee. We talk about the Joint Maritime Committee, Mr. Speaker, honorable members, because there are certain things in this sector we need to know. For the protection of our own local products, and for the externalities of whether we are operating in the IEZ or the EEZ, we have to look at all of these things. But let me read this provision in here in clause 16. Page 16, clause 11A, C, and B. Maybe I'll just read one, Mr. Chief Minister. Go to clause 11. Clause 11. Clause 11. A. The protection of Sierra Leone fisheries. The side note is joint maritime committee. That's one of their responsibilities. Or we need to know. It's not only on human security aspects. Even on our resources, on our natural resources, they have a widespread of what they can do in the security sector. So that's why they are divided into different committees. These committees you can see are headed by professionals. That's why they are not named people. They have not said Mr. A should be there. They have said in this joint maritime committee, there are members who are represented, and their functions, one of the functions, the protection of Sierra Leone fisheries and maritime resources from illegal fishing. Mr. Chief Minister, from illegal fishing. The other one quickly is E, 17, E, I will leave the others, E. Effective management of our fisheries and marine resources to meet local demand. We have had people are closing fishing time. We are having difficulties in doing in the marine sector. Mr. Minister, there is no way we are going to play magic if you don't take some of the committees into consideration. They gather intelligence and they are not acting on them. They will disseminate it to relevant NDAs, expecting them to enforce what they have given to them. That's how the state runs. That's how the state runs. And if we do that, we should have a coordinated system that will respect for each institution, department, so they can collaborate. That is why when you are working in governance, you should not be malicious. There should be no malice. There should be a synergy in cooperation. There should be synergy in dissemination of information. So that is why in this group of the security sector, making reference to the maritime sector. Mr. Speaker, honorable members, I see the National Security Coordinator. We have seen, as I said, I will tend to read, in fact, the National Security Coordinator, with the NS code, responsible to give a license to private, to those private security agencies. They are also responsible to gather those intelligence that they get from CISA whatsoever. It's a very high position. But what matters much is a collaboration. And once you have done in a bill, and the bill he said there is a coordination. It's a very important department. That is the National Disaster Management Agency. Now, what is happening? You see, people are asking why are we doing with the SPS? There is overlap. They have asked those questions. This disaster management agency, it was under the National Security Office. Yes, ONS, the Office of National Security. It was there, and staff were having a department, but they are doing very well. So what they have done, they have intertwined their responsibility, even though they are independent now. But in terms of collaboration, in terms of functioning, the NS code has a responsibility because these are disaster things and security related. You have to work with this particular department. I am no malice. You don't need to say, I'm not talking to Mr. Senge, Dr. Senge. I'm not talking to Mr. Singapore. We have differences because of differences in personality. No, it's not about that. It is about the working relationship for the good of Sierra Leone. So in this provision that you have done, you said there is clear collaboration for the National Security Coordinator, which is the NS code, whom that of the management of the disaster department. That is that. So they need to collaborate. It's very clear with that one, and that one has no compromise. But I have a concern. I have concern about Section 61 of the Constitution, in line with clause 23 of this bill. In line with clause 23. I will tend to read. I have never seen this one in the other bills or we have enacted. But I'm not seeing a reason why it is enshrined in this bill. But I will tend to stimulate the argument so that when we come to the committee stage, people can understand why we are kicking it out, not out for malice, for the neatness of our laws that we make, for the continuation and the affirmatives in law. We don't make laws and we break them by parts. We make law consistent with the existing legislations. So let me make reference to this. Section 61 of the Constitution. Section 61 of the Constitution. The president has the responsibility to hire and fire. Oh yes, hire and fire. But colleagues, please take your bill and follow me with page 23 of this one page, 23, clause 19. Clause 19. Clause 19. 23. It should be 19, 23, 19, 17, 3, tenure of office. Going to just go to 23 page, the upper page of that one. That has to do with 3. Now they said, we are the National Security Coordinator or the Deputy National Security Coordinator is removed from office before the end of the term to which he had been appointed under subsection 1 supra. Subsection 1 supra, he shall be paid salaries and other emoluments in lieu of remaining period. Why? Section 61. Forget about whether you have misconduct. Forget about what has happened. The provision, the ground norm is very clear on that. When you are fired, you are fired. In fact, you are giving end of term benefits. Why they are not going to pay you for the remaining term of office? So it means you are going against the spirit of Section 61, Mr. Minister. That one cannot be accepted. In fact, for the NS code and the CISA, the director of CISA, two provision is given for us for that. No, we can, if they need other benefit, let us incorporate it in other forms. But we cannot be seen one time we are blowing hot and one time we are going cold, and these are texts of evidence in our laws. No, we can't do it. There is no way we have done that. If we have done that, we call through Mr. Speaker, we ask for repeal. Because I don't want the NS code or the director of CISA to say we are biased. So we are looking for where this provision is possible, and we direct the spirit of 61. I beg to differ from this, and I call my colleagues that I will stand to repeal this aspect or not to accept it. Oh, the only one. Yes. Proceed. As I said, colleagues, also, when we pass the law that has to do with currency numbering, what I have seen in 2 of the penalties, in fact, trust me, for us to even start to monitorize penalty for security matters, we start to think about we are encouraging the crime on security matters to continue unabated. No, we should not do that. We should cross-examine and ascertain the level of crime committed, Mr. Speaker. We have not even verified in this position the crimes committed in this bill, and we have levied fines. No. In other countries, in other places, you are executed for committing certain laws in terms of national security. Other places, you are jailed for life imprisonment, depending on the gravity of the situation. So we should not be seen as a progressive parliament under your watch, monitorizing penalty for national security. We should not mortgage it. So in fact, what they have done, without giving it, Mr. Speaker, they gave the currency numbering differently. They said we are in NLE 200 million. In NLE, talking about billions. I don't know what charge is that. If I can charge you in billions, it means the gravity of that crime. You should be in jail. You should be in jail. So for me, even they have given a wrong nomenclature to the penalties by monitorizing it. We should not tolerate it. In fact, we should ask for the gravity of the law, the crime committed, and we levy penalties that befit the state, not the individual. Not the individual. And human security issues are not child's play. So, Mr. Minister, take note of for that one. Yeah. So we have dealt with that, talking about the side note about tenure of office. Section 61 cannot be compromised. Cum Section 171, subsection 15. As I said for my colleagues in Parliament, that they have the constitutional right for Section 93, subsection 6 of the Constitution. We can also not compromise that. But they have said, with the leave of this Mr. Speaker sitting, they can take situation for them not to disclose certain information to members. But in fact, they are saying we can even go to the court. That's the National Security Council, cum the Speaker of Parliament, to maintain consistency and that of cooperation with one another at different levels. Because the arms of government are different. We are the legislative, they are the executive. So if you want for us to compromise, you should make a provision of the law so that we can all cooperate under the law. Mr. Speaker, honorable members. Mr. Minister, part 5. Part 5. He said collaboration. He said ministerial responsibilities. Ministerial responsibilities. I will read for my colleagues, clause 22, for you to tell us what are the ministerial responsibilities. What you have not seen in this bill, colleagues, is the direct involvement. I know members stated it. We don't want to politicize these entities. As we have said, they are at different sectors, parts. Part 1, 2, 3, 4, 5, up to 11. And we want to maintain professionalism in them. But there is a policy role, Mr. Minister. There is a policy role given to some of these ministries. The Minister of Defense, cum the Minister of Internal Affairs. But now we are talking about ministerial responsibilities. And the reason why I'm asking you so that we can get clarification on clause 22 is to also understand what type of responsibilities are given to them. Is it on policy drive? Are we trying to politicize these sectors? So let's go to clause 22, colleagues. Side note, ministerial responsibility. Yeah, we are exactly. You have said the president may is not affirmed. From time to time, assign ministerial responsibility for agencies to set ministers, other than the Minister of Defense. Other than the Minister of Defense.
Sorry, Mr. Speaker, I want to call that time. It's 12. And then that SC5 to the suspension for the business of the House.
20 seconds.
I second the motion, Mr. Speaker.
All those in favor say aye.
Aye.
Those against say nay. The ayes have it. Proceed, leader.
Mr. Speaker, what is interesting though, they said, and the Minister of Internal Affairs, as the president may consider appropriate. The dangerous part of this one, we should have defined the role of a minister in the interpretation. So we should not have interference in terms of political structure, interfering with some of these structures that I said. We are talking about our political operations. So we need some verification from you. I think members will appreciate that one so much, and we need to have that. What you have done is not in the substantive law. It's the annual report. It's the annual report. I've tried to locate it. We have not seen it. We have never been given an annual report. And we don't have annual report because it's not stated. So what you have done, colleagues, clause 23, page 26, they are now making provisions for annual report to be laid in Parliament. They are now making reports. So let me read 23.2. Report approved under subsection 1, which you can read. Side note is annual report, as normal for the other laws we have, shall be tabled before Parliament. So in fact, we now start to question some of the activities of this sector because they are making exclusion of their activities to the public through document laid in Parliament. So colleagues, we have a leverage here which we can operate. Let us look at the functions of, as I said, we don't want to go into much of their functions, which is very clear. But let me go to the Director General, clause 25. Don't forget, you have to also look at the functions of the National Security Coordinator, which is the NS code. He has enormous responsibility. I did not read them because it's so much. Very interesting collaborative roles, coordinating security intelligence from different sectors, and put that one together with CISA, with other committee members, so they can forward that one to the National Security Council. That function of the NS Court is really key, coming from the Department of National Security, the Office of National Security. Clause 25, Mr. Minister. Clause 25, 2C. We need clarification on this. Colleagues, page 27. Ensure that the agency is not in performance of its function. Let me direct you, functions of the Director General. We are talking about functions of the Director General. Under the Central Intelligence and Security Agency, CISA. So we are saying we are not experts. And I believe that if you have them, perhaps by the time you make rapport, you give us this explicit clarification on this matter that I'm putting forward. 2C, page 27. Ensure that the agency is not in the performance of the functions influenced by consideration not relevant to such functions, and that no act is performed that could give rise to any reasonable suggestions that the agency is concerned in furthering, protecting or undermining the interests of any particular sector of the population, any political party or organization in Sierra Leone. I have read that one over and over, trying to read it in tandem with the superposition provision, try to look at the comparative substantive document we have in the substantive law. So this provision, Mr. Minister, we just need an explanation on it. If you can't, when we come to the committee stage, we'll still ask you, why do we need to maintain it? Or do we need to digress on this particular provision? So for the better security operations for this particular clause. Perhaps I'm finding it difficult by myself to understand what you are talking about. But when we come to this one, we can deal with it explicitly with your directives. Mr. Speaker, honorable members, Toku. There is not really much on Toku. Only that also they need to tell us that in the structural presentation of Toku, the advisory board with the IG, the Chief of Defense Staff, is still on the advisory board. When you come to the management committee, you have the AIGs and the other officers. But in the presentation, what you have done, you have presented the management committee first, and now you are making reference to go to the advisory board, and advisory board is taking care of the management committee, which you are reporting to. So perhaps we need to look at the structural. Perhaps we need to look at the replacement of the provision. Whether we should have the advisory board to have a proper presentation. If I'm reading a document, I should be able to understand that the management committee is not superior than the advisory board. Because even the committee members by rank, they are far senior than those in the management committee. So I think maybe I don't know why they did that, but we need to clarify that one. Now let me now come specifically what he brought to us. Our members, they have asked whether we should, what is the implication? And as I said, we have looked at all the rules for different sectors. The CISA, the NSCOD, the DG's rules, the TOCO. We have looking at all of them. But you now brought the State Protection Service, Part 7. Part 7, colleagues. Part 7. First, let me say this. You should not make law for individuals. You should not make law try to discriminate other people. This office is going to be created by the authority of the president. By the authority of the president. It is clear. It is stated there. But what is not clear, which you read from your presentation, that the president will play a supervisory role for this close protection. You read it, but it's not in the bill. Now, what is worrisome? If you are protecting me, you must have arms and ammunition. And we are creating director where you are going to be armed. What you have done, you have formed a committee, but that committee is not really, there is no nexus. The authority given by the president tying that committee to the supervisory of the president you mentioned. So there is a lacuna, and it will cause a problem. So we are looking about the officer responsible of the president. So you have said the day-to-day responsibility of the director, but you did not talk about the day-to-day reporting of the DG to the president. No, it's not there. You know, it's not even mentioned in the bill that they should play a supervisory role. They said the president by authority appoints the director. But that one is a whole crisis. We can't allow. There must be a reporting mechanism. Now, they went further to state that we should have qualifications for the NS code. For the NS code, they said masters, 10 years experience. For the SPS director, you are saying masters, no experience giving. Oh yes, I will read the provisions. I'm coming there very soon. The provisions are there. They did not talk about the qualifications. Yes, they did, but you did not mention about what should be the years of experience. You are talking about there are people in the police force. My colleagues, you are talking about what will be the fate of those in the police that are acting as BGs. There is also trained personnel in the military. These are entities, these are well-trained people. Now, in the recruitment, you said nobody in the police force or in the military should be appointed to be the director. No, we are not accepting. It is in the right sense of the president, with wisdom, to appoint anybody in that position. But you cannot make law to discriminate other sectors. In fact, they are playing that role. Because they are playing that role, you need them. But it behooves the president to appoint who he wants to appoint.
Leader of government business.
Yes, sir.
I know you very well. I know you very well. So are you still standing?
Now I wrap up.
He's standing, but he's not shouting.
Mr. Speaker, I will not. It's there. The provisions are there, clear. Go to the one I've mentioned. Let me read. Page 37D. Page 37D. He said, it's not in appointment, the side note, the director, appointment of the director. They said, the person shall not be qualified for appointment as director. 37D is not a serving member of the Republic of Sierra Leone Armed Forces or Sierra Leone Police Force. Why? Why not state? Other security sector. What about the fire force, the prisons officers, and other sectors? Why not? No, we can't accept this clause. Let us leave it open for the good of people who have say in our positions. In fact, we are not talking about transition rule, but what is going to be the fate of those in the police and the military? We have the presidential bodyguards. There is no provision for them here. Perhaps I cannot say there is regulation coming, which we can stay talking about how do we do I really want to say transition. There is no transition here because this structure, the SPS, is not existing at the moment. You mentioned, said we have hard work arrangement. Protecting the president is not an hard work arrangement, sir. I beg to differ. It is a real structural arrangement coming from the Inspector General of Police and coming from the military background. Oh yes, it's not hard work arrangement. So when we are confused, we are not against the structured provision. But when we are confused, it's because they are trying to eliminate certain people who have worked in this position for over 20 years. Well, we're not going to allow that for our PSU too. We can allow the president to appoint, but in the responsibility, who are qualified and those who are not qualified cannot be treated that way. Fast forward. You said those who they can protect. For my colleague, Mr. Speaker, you are covered under the Parliamentary Service Act. We cannot reinstate the law. As I said, reinstate the law, you are altering the law. We cannot go to that. I think that one is clear. Protecting you is the responsibility of Parliament. Sacrosanct. We cannot joke with that one. But you are talking about leaders of Parliament. We are elected officers. A leader of Parliament, the opposition leader, and you are saying minister, Mr. Minister, they can be protected. What about the leaders of Parliament? You put us on our options. In this bill, we are on our options. We are under options. I'm not against it. Don't misquote. Don't misconstrue me.
They don't know by right you are the prime minister.
Nobody should be from that position.
They are making me as if
You are the prime minister.
exactly. One country, one people.
Or why is not here?
Oh, why? Oh, side. Oh, yeah. My parliamentary, respect. Mr. Speaker, let me tell you one thing that they do. Anytime I'm reading the bill, I have the substantive law with me. I try to do comparison so I cannot confuse my chairman of policy committee. You know what they did? As I said, we are going to put experience for the director for SPS. When they came to the area for the deputy for director for under the SPS, they said masters. For the deputy director for the NS code, it's first degree. What is most senior? Most person at the level of the National Security Council, National Security Office. With that of the SPS, you are talking about master, and the deputy there is not masters. It is bill, we are going to remove it. Has no place. It's going. We cannot accept that one. Consistency of the law, neatness of proceeding must be maintained by this house. We need to about flip-flop business. We're not good one.
The prime minister is
You see, if you are afraid or when you are going to read, take a look at the CISA. Take a look at the Office of National Security Coordinator. Look at them. Look at the qualification given to them. Look at how their deputies are recruited. But when it comes to state protection service, as if they want to tailor it for someone, we should discourage them doing that, and it's not going to happen here. They did it for the CISA only first degree for deputy. They did for the NS code deputy only first degree. When they came to the SPS, they said masters, no years of experience. And for those ones, for the deputies, they are talking about years of experience. 5 years. You are going to protect the SO2, Mr. Chief Minister. You are taking a juvenile to protect you without requisite qualifications, requisite experience. You are playing with your life. For us, that is why we have made provision. For us, Parliament will protect our speaker. We will not bring someone else.
the speaker now and after.
Yes, exactly. So, in fact, I don't want to belabor the point. This one, when we come to the committee, as he said, we will spread this one. Mr. Speaker, you are a lawyer by practice. You are a lawyer by profession. What about Supreme Court judges? If you talk about ministers, you have left out Supreme Court judges. Is it fair to our nations? Supreme Court judges must be protected. They only talk about SO2, they only talk about the Chief Justice. Oh yes, they can't more than talk about you, they forget to don't make law for protect you. In this being, sir, how do we? Am I not being protected, sir?
You are protected.
We are the prime ministers of the system.
So, let me wrap up now. Under the miscellaneous provisions which I stated, I will not go direct. I have dealt with penalties. I'm not going to allow myself to be dragged into security issues. Why we should make law to protect humanity and the state, we should not dilute that one. It should be very strong in terms of protection. These are under miscellaneous provision. Now let me take you to clause 62. We are not talking about part 9. Wrap it up. Wrap it. Very, very close. 52. Mr. Speaker, I need your attention. We did something for this provision. It is not. I have the answer, but I'm not going to throw spanners into the works. I have the answers, but I'm not going to throw spanners into the works. From experience, I have followed a lot of things happening. When you are working for this sector, security sector, at this level, for example, now we have the NS code, we have the CISA, we have those who are in Toko coming from the police and other sectors. You should be able to maintain confidentiality even after your service. People, because of the politicization of our system, we have politicized our way of thinking. We don't even rationalize the state anymore. We don't even think about national security issues. After the Astami court president, we have terminated all. When the former president and my Nkrumah was there, terminated some people. They will sit in corners, try to divulge, disseminate confidential information to the public. And as I said, which I stated and I debated it, I will also debate you, Mr. Chief Minister. I will follow it this time. It is in the answer that we said anybody, punitive measures to be taken for those who are involved in said practice. But today, let me tell you, colleagues, not here. It's not here. But let me attempt just to take you my last quote of reading, clause 62, so you can understand what I'm talking about. Confidentiality. We are not going to jeopardize the state at the expense of people because they feel that today they are not with President Bio. They are appointed by him. Yeah, of course. If you want your soul, you can be appointed by any good president. You don't need to fear. And those appointments cannot be done because of fear belong to party A or party B. Let us, for goodness sake, try to protect the interests of the state, not the interests of political parties or individuals. 52. A member of the council shall not, without the consent of the council in writing, publish or disclose the content of a document, communication, or information which relates to his functions and duties under this act. That is when you're in office. So I am now debating for post office. After you have gone, after you have left, punitive measures should be taken. We need to look for insertion for that because you cannot jeopardize our national security for anything. So, Mr. Speaker, honorable colleagues, I will go on and on and on.
But very necessary.
But let me say this.
But necessary.
You don't do now.
Very necessary.
53 is giving comfort for 52 when you're in office. I am chasing those who are not in office. Those people I'm chasing. I'm not chasing those in office. They can be fired if you misbehave. If you get misconduct, you can be fired. I'm talking about those who can disseminate information after your term of office. Those people should be taken with some serious measures, punitive measures to be taken against them. We are not going to leave them like that. But regulations, end of presentation. Regulation must be treated very seriously. In another regulation, we want to know whether the state protection service is not disadvantaged those who are doing the body service, the bodyguard service and the police, those who have worked for the president, those in the military who are serving the president as presidential protection unit. We need to get that one clear. We don't know whether to bring it in the regulations or in other forms of administration. But what I know that we have to treat them very seriously. It's becoming something of concern. But as we said, we are going to commit this bill to the legislative committee, and Mr. Speaker said we add other committees to it to make sure that it's properly scrutinized. But whether it's scrutinized it or not, we come here. My position that I've made, I will defend them for the interest of this country. The point that I've highlighted, I will talk about them with reference to substantive things I have and also for the interest of national security. Thank you, colleagues, for your attention. Thank you, Mr. Speaker, for giving me the time to do my presentation. Thank you. The Lord bless us.
Mr. Speaker, can I have just maybe 30 seconds? I just want to make a clarification on what that said.
No, that's not good.
No, Mr. Speaker, please hear me out.
After the leader, Chief Whip, after rounding up. After rounding up, you cannot.
Stand on.
You know that, not so? Yes, Chief Minister, briefly.
Thank you very much, Mr. Speaker and honorable members. This is really wonderful for our state. The National Security and Central Intelligence Act of 2002 existed, and it took us another 20 years. That act was set up by the SLPD government. It took us another 20 years for this government to bring the National Security and Central Intelligence Act of 2023. Within that period, security evolved. And it's taken us another 3 years for us to come with an addition with the National Security and Central Intelligence Act. During that period, this government has uncovered planned coups, has responded to a failed coup, have engaged with the protection of our country across its borders, and has maintained Sierra Leone to being one of the most peaceful and safe countries in the world. I mention this, Mr. Speaker and honorable members, to say that the professionals who we have in our security sector, from the Office of the National Security to the police, to the CISA, to the military, and under the leadership of His Excellency President Julius Malabio, the National Security Council, are top professionals, and professionals who are working every day, morning through night, to ensure that we are coordinating, we are cooperating, and we are collaborating. The Sierra Leone Police has very clear mandates: law enforcement, investigation, public order. The Republic of Sierra Leone Armed Forces caters for our national defense and external security. ONS, CISA, and all the entities that are captured in the National Security and Central Intelligence Act provide strategic intelligence collection and analysis. What the SPS is here to do is to ensure that we can better structure, better coordinate to provide protection, protective security for our President, Vice President, and the designated officials who are listed within the Act. Mr. Speaker, honorable members, the United States has a Secret Service. The United Kingdom has a Royalty and Specialist Protection. India has the Special Protection Group. The Philippines has the Presidential Security Group. South Africa has the Presidential Protection Service. Our friends and our brothers in Liberia have the Executive Protection Service. In Nigeria, they have the State Security Service. These agencies are not developed out of thin air. I want to assure you, Mr. Speaker, and the honorable members of Parliament, that the reason why we saw the ONS coordinator in the room, the reason why we saw the other security leaders across the board in the room, is because this unit, this service is developed with close collaboration, close leadership from those different members of the existing forces that we have. And there is nothing that is in this act that will compete with, that will remove, that will affect the work of the existing forces. And I want to highlight that the SPS itself has a committee, and in that committee, we have the Chief of Defense Staff, the Inspector General of Police, the Director General CISA, the Chief of Staff in the Office of the President, the Director General, Ministry of Foreign Affairs and International Cooperation, the Financial Secretary, and the Director, State Protection Service. This underscores that there is absolutely no role taking, no gerrymandering, no taking of authority or power from any of the existing forces and security that we have. Mr. Speaker, honorable members, the primary change that we're doing to the National Security and Central Intelligence Act from the 2023 to the 2025, the primary one is that we're adding a new chapter. There's absolutely nothing else that is being changed. We are reorganizing, but there's nothing that's been removed in any of the other sections or being added. On the contrary, we've maintained them, and I think, Mr. Speaker, honorable members, and based on the submission from all of you, perhaps in the committee stage, some of those things that you highlighted that are now in the bill in front of you, you could look at, and we'll all look and work with you to ensure that it happens. But that was the primary concern about duplication, and yes, I can assure you that that is not an issue in this bill. The people who will be in the SPS will be on secondment from the police and will be on secondment from the military. And there will be people who will be specially recruited to deliver specialized activities. I was in Spain on official function, and I had dinner with the former AG of Spain. The bodyguard who they assigned to me used to be the bodyguard of the former AG. And he invited me out to dinner, and the bodyguard said, "No, I cannot sit in this car." But then I begged that I'll go because he's my friend. He insisted that he would drive with us. This guy used to be his boss, and he did not listen to him because his duty was to protect me. We need to have professionals who are taking care of our leaders, including the speaker and former speaker, and I hear you as we determine all those people who are on the VIP list. The leader of government business.
No, they have done their draft.
And it is important that the people who are next to us, or protecting us, are not people who are taking instructions and directives from some person who is in the police somewhere in the LUC unit, but that actually they are professionals who are going by a code of conduct, who are supervised by the NS Code, who are supervised by the SPS Council. And when we do that, that's how we can guarantee that there is professionalism, that's how we can guarantee that it is not politicized, and that's how we can guarantee that we are protecting the leaders and the people of this country. Mr. Speaker, honorable members, I want to end by saying that what we have seen in Sierra Leone under the leadership of His Excellency, and as I mentioned, from 2002 by the SLPP government, is we've seen that we have opened up the space, freedom. There's more freedoms that we have in this country today than we had prior to 2018. Freedom for journalists, freedom for citizens. But at the same time, we're bringing in laws and we're bringing in institutions that will allow us to be free and be protected and safe at the same time. All of us drive ourselves at night. Many of us drive ourselves at night. We don't have police vehicles that are in front of us and two behind us. People abuse us on social media every day, and they still come and shake our hands and snap photos with us. It's because His Excellency has made Sierra Leone freer and safer at the same time. But we cannot take that safety for granted. We have seen how the world is evolving through security. This is precisely why we need the SPS, a professional service, a service that follows code of conduct, and a service that is guided by a committee that is put together by His Excellency that includes leaders of all of these different forces. So, Mr. Speaker, honorable members of Parliament, I move that the bill entitled the National Security and Central Intelligence Act 2025 be read the second time. Thank you.
Honorable members, the question is that the bill entitled the National Security and Central Intelligence Act 2025 be read the second time. All those in favor say aye. Aye. Those against say nay. The ayes have it.
The bill entitled the National Security and Central Intelligence Act 2025, being an act to repeal and replace the National Security and Central Intelligence Act 2023, Act number 2 of 2023, to provide for the internal and external security of Sierra Leone and to provide for other related matters, has been read the second time.
Mr. Speaker, honorable colleagues, as the Chief Minister said, presentations that we have done, based on the issues that we have raised, I've said we are not against putting another provision and amend and repealing the substantive law with the proposed law we have, but there are certain things that we need to do. So they are even asked us to expand the committee meetings for the legislative committee to co-opt internal affairs and defense. So on what you have said and presented by the proposal from colleagues, let me stand on SO 51-1 for the committal of this bill to the legislative committee. I so move, Mr. Speaker.
Any seconder?
I so second.
All those in favor say aye. Aye. Those against say nay. The ayes have it.
Pursuant to Standing Order 51-1, the bill has been committed to the Legislative Committee for further scrutiny.
Thank you very much, Mr. Minister, Mr. Chief Minister. Thank you very much for coming. You may leave.
Thank you.
Of course, we cannot proceed with the other item on the other paper, and I'm inviting the leaders of Parliament to go to my chambers and have a conversation with the Minister of Transport and Aviation after the adjournment. Can you do an application for the amendment? Yes, sure. We are meeting tomorrow.
Mr. Speaker.
And Chief Minister, please, let's go to my chambers. I want you to be present.
Mr. Speaker, honorable members, based on the position Mr. Speaker proposed, that item, Mr. Speaker, we shall leave. Can you please permit me today, based on constitutional standing order provision, to just quickly go over the business statement before I amend the other paper?
Okay.
Yeah, sure. Okay, yeah.
Well, can you do the?
Yeah, I mean amendments, yes.
Mr. Levy, please take the Minister of Transport and Aviation and the Chief Minister to my chambers. Yes, let them go to my chambers. We are adjourning.
Mr. Speaker, honorable members. Mr. Speaker, honorable members, I move that the other paper be amended also. Item 4, item 5B, Roman figure 5B, no 6B. 6B be expunged from the other paper. 6B be expunged.
Any seconder?
I saw second as
I think, leader, if 6B is to be expunged, then
ODA?
number 6, oh, 6B, okay. It's still 6.
Yes.
Any seconder? Any seconder?
I so second, Mr. Speaker.
All those in favor say aye.
Aye.
Those against say nay. The ayes have it.
Motion moved by the Leader of Government Business and Majority Leader for amending the order paper has been carried.
Or you want to call him the Prime Minister?
It's just a quick business statement, Mr. Speaker, and we have that one circulated to colleagues to get the full details of what we have in the internal notice paper. One, on a lane of papers. Document before the House.
Leader, since we are doing the constitutional review, can we just make you Prime Minister?
Mohammed,
That would be very nice.
still una need to think of business paper. That's a good one. The lane of papers. Document before the House, the internal notice paper from the Business Committee. Lane of papers. Anthony General, Minister of Justice. The Copyright Regulation 2024. The Copyright Act 2011, Act number 6 of 2011. Statutory Instrument number 12 of 2024. B. Under lane of papers, the Minister of the Environment and Climate Change, the Sierra Leone Community-Based Mangrove Conservation and Restoration Project SERS Simple Equitable Revenue Sharing Agreement. C. Veronica K. Lane of the delegation of the ECOWAS Parliament, Sierra Leone branch. Report on the 2024 second ordinary session of the ECOWAS Parliament held in Abuja, Nigeria, from the 1st to the 13th October 2025. Report of the 2026 first parliamentary seminar and the first extraordinary session of the ECOWAS Parliament held in Abuja, Nigeria, from the 20th February to the 1st March 2026. Government motion. The Minister of Transport and Aviation. Advanced Transport. Advanced Passenger Information. API regulation. Drone regulation. 3. Roman 3. Amendment to Article 10 of subsection 4 of the Constitution of the Africa Civil Aviation Commission, AFAC, adopted by the 28th ordinary session of the Assembly of the African Union at Addis Ababa, Ethiopia, on the 31st January 2017. Bills. The Public Finance Management Act as amended, Act 2023, the Minister of Finance. B. As a B, the State-Owned Enterprise and Governance Act 2025. We are now in the second reading of this particular bill. We have done that twice, committee stage. Now we report. C. Under Minister of Finance, again, the Deposit Protection Fund Act 2024. The Minister of Finance. The Petroleum Exploration and Production Amendment Act 2024. The Attorney General and Minister of Justice has to do that one for the bill. The Sierra Leone Correctional Service Amendment Act 2024. The Attorney General and Minister of Justice. The Workers' Compensation Act 2024. The Minister of Employment, Labour and Social Security. G. The Occupation Safety and Health Act 2024. The Minister of Labour and Social Security. The Safe Motherhood and Reproductive Health Care Act 2024. The Minister of Health and Sanitation. The Merchant Shipping Act 2025. The Minister of Transport and Aviation. The Mediation Act 2025, the Attorney General Minister of Justice. K. Constitution of Sierra Leone Amendment Act 2025, the Attorney General Minister of Justice. The Credit Reference Act 2025, the Minister of Finance. M. The Legal Practitioners Act 2025, the Attorney General and Minister of Justice. Last but not the least, the National Security and Central Intelligence Act 2025, the Chief Minister, which we have about to finish. Thank you, Mr. Speaker. This is coming from the Business Committee.
Honorable members, this sitting is adjourned to tomorrow, Friday, 27th March 2026 at 10 a.m. All the leaders, quickly to my chambers.
Including chairman. No, chairman are not included. Chairman are not included. That's the second layer.
The second layer follow.
That's the second layer. You can meet to DSPK. No, to DSPK. The second layer will be to DSPK. Hey.
Radio Julia.
On FM 103.9.
Radio Julia.
On FM 103.9.